Good morning. Please be seated. Thank you. Well, may I begin by welcoming all of those of you who have attended Waverley Gate this morning. And also all of those who are watching and listening to proceedings remotely. Today marks another important staging post in the progress of the inquiry, this being the first public hearing to take place since the Cabinet Secretary formally set up the inquiry in April of this year. As its description suggests, the broad purpose of the preliminary hearing is to provide a forum for senior counsel to the inquiry, to provide an update on progress so far, and to provide an outline of what you can expect to happen as the inquiry takes forward its investigations. It also enables the recognised legal representatives of the core participants, if they choose to raise matters of interest or concern arising from what has been outlined. In that respect, may I thank those responsible for submitting written submissions in advance of this hearing. That has enabled focus to be brought to bear on the matters of most immediate interest and concern to those whom you represent. It is not my intention this morning to usurp counsel's role by involving myself in the detail of how we have reached this point and the direction of travel hereafter. You will hear all about that in just a moment. But I do wish to take this opportunity publicly to renew the commitment I made at the public hearings in October to lead an inquiry that is at once independent, fair and thorough, but in a spirit of mutual cooperation and, where possible, consensus with the legal representatives of core participants and others. I encourage engagement with the inquiry, not least in relation to the list of issues which has been published on the inquiry's website, and to which core participants have been invited to contribute. I also stated in October that I would not hesitate to use my statutory powers to call for and to recover evidence, and in due course to compel the attendance of witnesses in order to exhaust the terms of reference now fixed by the Cabinet Secretary. Nothing has changed in that respect. Given their scope and inherent complexities, exhausting the terms of reference as they now stand will be a significant challenge for the inquiry team, as is the proposed timetable that is about to be outlined to you. It is a challenge which, with the assistance of all of you, my team and I embrace. I have said before, and I repeat, that I will be flexible in my interpretation of the terms of reference, applying to them a broad rather than a narrow construction as to what they empower me to do. At its best, healthcare provision in this country is of the highest order of excellence. That is why, when things have gone wrong, it is of very considerable public importance and obvious public interest to find out why and to learn what lessons there are to be learned. That, in essence, is the challenge we have been set. Finally, I hope you will allow me to say at the outset that I do attach considerable importance to the spirit in which I intend this inquiry to be conducted now that we are moving away from its establishment phase. It is more than likely that this hearing and those to come will be difficult for many. But consistent with the inquiry's own statement of protocols and principles published on the inquiry website, I would ask that all those in attendance at or otherwise involved in the work of the inquiry interact with others with courtesy and with respect, whether at this hearing or subsequently. It is in that spirit that the inquiry is likely to obtain the best possible evidence to support its investigations, and that can only be to the advantage of us all.